How does the New York Fair Act impact business disputes? Breaking news for businesses in New York. The New York Fair Act has just been passed, and it is making waves in the realm of business disputes. If you are a business owner or involved in any contracts, you will want to pay attention to this development. Many are searching for clarity on how this new law affects their operations. Let's break down the key points that you need to know. The New York Fair Act primarily regulates arbitration agreements in employment and business contracts. This means that businesses can no longer enforce mandatory arbitration clauses that prevent collective or class actions. Now, employees and consumers can pursue group claims, which is a significant shift in the legal landscape. One major impact of this law is the increased risk of litigation for businesses. Without the ability to enforce arbitration agreements that limit claims to individual actions, businesses may see a rise in class action lawsuits. This can lead to higher legal exposure and costs, as disputes will be resolved in court rather than through individual arbitration. Additionally, businesses may need to rethink their dispute resolution strategies. Many will have to move away from mandatory arbitration or revise their agreements to comply with the new restrictions. This change can lead to a more complex legal environment as businesses adjust to the new rules. Another effect of the Fair Act is the potential for higher legal costs. Class and collective actions typically involve more significant stakes for businesses. This often results in longer litigation timelines and greater legal fees compared to individual arbitration cases. Moreover, the dynamics of settlement negotiations may change. With the inability to limit claims to individual arbitration, businesses may find plaintiffs have more leverage when pursuing group claims. This can impact how settlements are negotiated and resolved. Overall, the New York Fair Act aims to provide greater access to the courts for employees and consumers. By restricting arbitration clauses that limit collective legal action, it opens the door for more group claims. For businesses, this means adapting to a new reality where litigation may become more common. It is essential for companies to adjust their risk management strategies and prepare for the changes ahead.